And now let's bring in our resident legal expert on all things Trump and the cases against him, trial lawyer Robert Barnes. Robert, thank you so much for coming on the program tonight. I want to ask you, first of all, before we get to Stormy Daniels, about these recent court filings from the Department of Justice that were released authorizing, when we go back to that Mar-a-Lago raid, the use of deadly force when the FBI agents swarmed the residence in August 2022 looking for classified documents. They were told to come armed with ammo, handcuffs, bolt cutters, all sorts of things, and even that they were prepared to engage with the Secret Service. It really looks like they were spoiling for a firefight here with the security agents at Mar-a-Lago and maybe even Trump himself. Robert, what's your reaction to these disclosures?
I think it shows the degree of the insanity of all of this, that they should have never done a search warrant on the president of the United States to begin with, the leading opponent of the incumbent administration, the former president, neither of which has ever happened before in American legal history. This was something they could have obtained these documents and information without even doing a search warrant in the first place. But if they were going to do a search warrant, it needed to be coordinated with the Secret Service so there would be no risk of it escalating. And it's only thanks to Trump's people preventing escalation that we didn't have a Ruby Ridge or a Waco or that level of disaster at Mar-a-Lago involving the former president and leading opponent of the Biden administration. So it shows how out of control the Biden administration is right now, that it almost was seeking out undue and unnecessary escalation that could have been a public travesty and tragedy for the world.
Well, I mean, that's what I want to ask you, Robert. I was reading all of these filings. I was absolutely shocked by how confrontational they were. And they were pretty much written like they were going to go raid a crack house down the road rather than, as you say, the residence of the former president. Is it far-fetched? Am I being conspiratorial here to think that there may have been elements involved with this planning who would have been hoping for less cooperation from the president's team?
I think that's absolutely the case. And the FBI's had a history of this being a problem. That's really how Waco got out of hand. There were people who were drafting that search warrant and that execution of it who wanted Waco, the people inside those buildings, to respond a certain way so they could escalate. And we know how that turned out. Similar to what happened at Ruby Ridge, that when you get these elements that want somebody to fight back, that want somebody to contest, that are doing things to escalate and raise the temperature rather than reduce it, you're inviting a public tragedy. And I think there were some people who really were wanting and hoping and seeking this to be escalated so in their minds they could further marginalize President Trump. Oh, look at what happened when the FBI tried to get the documents back. I think there's definitely an element of that, and it shows how out of control that element is within the current administration.
That's absolutely shocking stuff when you think about the implications of that. But I want to move on now to the Stormy Daniels trial and what a travesty that has become. Some comments from Alan Dershowitz, who's written a great piece in the New York Post talking about his experience watching from the inside. And he said that the judge in Donald Trump's trial was an absolute tyrant who seemed to automatically be ruling against the defendant at every turn. The judge excluded obviously relevant evidence when offered by the defense, while including irrelevant evidence offered by the prosecution. This seems to me, Robert, further evidence that this trial, which again, this case never would have been brought if Donald Trump wasn't running for president again, is just, as we say here in Australia, a stitch-up.
Oh, completely. I mean, this is a case that has never been brought against anybody before. They can't cite a single case where they've tried to allege this kind of so-called fraud on the public through a campaign donation. There's no comparable case where they've ever alleged a internal bookkeeping entry of a company that's not even a publicly traded company somehow defrauded anybody. How something could that happened after the election, because these bookkeeping entries were made while he was president, could impact the election also makes no sense. All of it is ludicrous, and as what Professor Dershowitz saw, he saw a kangaroo court that would make kangaroo courts look good by comparison. You have a judge excluding the media, excluding members of the public, lecturing lawyer witnesses on the stand and threatening to exclude all evidence relating to them that damages the case. He's granting objections from the prosecution before the defense even finishes its question. He's giving jury instructions that are wrong on the law in order to mislead the jury to a particular verdict. All of while he has gagged President Trump and prohibited him from defending himself in the court of public opinion on a case that is entirely about influencing the court of public opinion. That is a show trial. You have lawyers like Good Logic, Joe Neerman, who has a media company trying to seek to remove the gag order, and all he is getting is the runaround by the New York courts. This case has put the New York court system on trial, and it is damning of the New York court system, not President Trump.
Absolutely, but there was a big backfire in the case here. Robert Costello, who is a former lawyer for Michael Cohen, who so much of the case hinges on, contradicted Cohen's sworn testimony regarding Trump's knowledge of the Stormy Daniels hush money payment and said in the court that Cohen told him numerous times that Trump knew nothing about the payments. Is this going to make a difference? I mean, it seems like it's just embarrassment and fail after another for this case.
No honest jury could convict Donald Trump based on the evidence that's been presented. He didn't commit a crime. There's no evidence that he even ordered the bookkeeping entry to be made or to be made the way that it was made. There's no evidence that, in fact, it didn't represent legal expenses since it was payment to an attorney for a legal invoice listed as legal expenses. There's no evidence other than Cohen's self-serving testimony that he ever even told Trump about any of this. And that's based on a phone call that supposedly happened in 90 seconds or less, where he's really complaining about a 14-year-old kid harassing him. So there's no credible evidence. Cohen admitted he stole from President Trump. He embezzled from President Trump. He lied to President Trump. He lied to courts. He lied to Congress. He lied to the public. And he's making millions of dollars based on this trial. That is not somebody that could be considered a credible witness beyond a reasonable doubt in any court, other than a court that is as partisan and prejudiced as this New York court has been against President Trump.
Well, Robert, just explain to us quickly before we go this whole thing here, because I thought this was hilarious that Michael Cohen gets up on the stand and he winds up just saying, oh, by the way, I stole $100,000 from the former president. How does this make, him a credible witness? I kind of thought that in a criminal trial, if somebody admits to that sort of thing, they're not a reliable witness. But I'm not the law-talking guy. You are.
Yeah, I mean, I told people I would do this cross-examination for free because of how much fun it would be to cross-examine Michael Cohen. The best phone call I turned down was Michael Cohen years ago, who reached out to my offices, and I just didn't trust him. And so I was like, I'm not going to return that call, thank God. But you have a guy who embezzled from the person he's accusing, was involved in an extortion scheme against the person he's now accusing, who's admitted he stole from the person he's now accusing, who's admitted that he's lied about him repeatedly and routinely for years, and that he would profit from a conviction in this case. You have no credit. You have every level of incredulousness that is attached to the only witness who puts any intent evidence in front of the entire jury. Even James Carville said that's nuts. So when you can't even get Carville to think that it's a worthy case, that gives you an idea of what a joke the case really is.
Robert Barnes, thanks for your time, and I think you're right. If we're going to call this a kangaroo court, we'd be guilty of cruelty to kangaroos. Robert Barnes, again, thank you so much.